23 CR 005. State of Ohio versus Jeremy Hogsett. Present for the state's Assistant Prosecutor King. Present on behalf of the defendant's attorney Captain Hapner. And you are Jeremy Hogsett?
Yes, Your Honor.
All right. Mr. Hogsett's charged with grand theft by deception and tampering with records. Yes, tampering with records. And I believe this matter is set for trial August 29 and 30. Okay. Now, is discovery complete on both sides?
As far as we know, Your Honor.
It is from the state, Your Honor.
Okay. All right. And there are no pretrial motions, correct?
That's correct.
Correct.
All right. And has there been a signed rejection of the plea offer?
I don't know if that has happened. So this is, here's the year, your case number. So these are, that's what you're charged with. What the offer was, you agreed guilty to theft by deception. And the count two would be dismissed. And the state would recommend community control and restitution. So this is what you're saying, that you're rejecting that plea offer. Is that, so if that's what you're, then you need to sign here.
All right. For the record, is that what your client is signing?
It is.
All right. You
Yes.
give that prosecutor and get a copy of it then. Okay. Looking at the subpoenas, I see here you've subpoenaed 9 witnesses, Mr. King, and anticipate calling all of those 9.
We subpoenaed.
Well, actually, it was for that was for the July trial.
Yeah, for the 29th, we've subpoenaed 10. Likely be issuing an additional subpoena. I doubt we'll have 11 witnesses. That will get trimmed down as we get closer to the trial date. I don't know the exact number at this moment, though, Your Honor.
Okay. And Ms. Hapner, how many witnesses would you anticipate calling?
I'm waiting for some information from my client, 3 or 4.
All right. Oh, I didn't put on record. Is there the representative of the alleged victim been notified of the time, place, and purpose of this hearing?
Yes, Your Honor, they're not present today.
All right. Okay. All right. So, and let's see, was there an alibi defense filed in this?
There was.
All right. And I also note that there was a polygraph stipulation filed back in July. Did that examination take place?
It did.
Yes, sir.
All right. Is that, and that person has been listed by the state as a possible witness, I see.
Listed and subpoenaed, yes.
Pardon me?
Listed and subpoenaed.
Okay. All right. Okay. All right. Anything else that needs to be discussed at this time?
No, Your Honor.
So this looks like it's going to be a 2-day trial
I'd say it has the potential.
with a number of witnesses, so we'll
Yes, sir.
anticipate that then. All right. Anything else?
No, Your Honor.
All right. Thank you. We'll see you then on the 29th, Mr. Hogsett. All right. Are you Errol Ty Baker appearing there from the jail?
Yes, sir.
All right. This is case number 23 CR 130, State of Ohio versus Errol Tyrone Ty Baker. Mr. Baker's appearing by Zoom from the jail. And his attorney is William Satina, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor Adam King. This is set for a pretrial, and I have been presented with a plea of guilty form. So, Mr. Satina, are you and your client both in agreement that this matter can be conducted by Zoom rather than an in-person courtroom appearance?
Yes, Your Honor.
And you're all right with that, Mr. Baker?
Yes, Your Honor.
All right. Since you're not seated in the courtroom next to your attorney, in the event that you need to talk with him or ask him a question about anything, then just let me know, and I can put you and him into what's called a breakout room, where there'll just be the two of you that will be able to speak to each other and see each other. No one else will be able to see you, and the deputy there in the room would step out of the room during that consultation so that it's private. Okay? All right. Now, Mr. Baker is charged in a 4-count indictment with aggravated trafficking and aggravated possession of methamphetamine, second-degree felonies, and having a weapon under disability, a third-degree felony, and a forfeiture specification. This is the final pretrial. The trial was set for September the 11th. Now, Mr. Baker, I have this plea of guilty form here, which indicates that you're going to plead guilty to counts 1 and 4. Now, I'm going to hold that up to the screen and show that, or to the camera, so it'll show on your screen there. And do you see your name and case number there and the plea of guilty and the 2 counts? It says counts 1 and 4 that you're pleading guilty to?
Yes, Your Honor.
Right on. This is a 4-page document, I believe. And on page 4, at the very top of the page, there's a sentence that reads, "I enter this plea voluntarily." And this appears to be a copy of a document signed by you and your attorney. I'm going to hold this up to the screen and ask if that's your signature right below the sentence that reads, "I enter this plea voluntarily."
Yes, Your Honor.
All right. And when did you sign this agreement, Mr. Baker?
Yesterday, August 15th.
All right. And was your attorney there at the jail to go over it with you?
Yes, sir.
And he explained everything to you before you signed it?
Yes, sir.
Did you understand, Mr. Baker, that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And did you feel that you had enough time to fully consider this matter before making the decision to sign this document?
Yes, Your Honor.
And did you sign it voluntarily yesterday?
Yes, sir.
And are you going forward today, pursuant to the terms of this agreement, voluntarily?
Yes, sir.
All right. Now, the agreement states, as I indicated earlier, that you're going to plead guilty to count 1, aggravated trafficking of methamphetamine under 2925.03A1 of the revised code, which is a second-degree felony, and to the forfeiture specification under 2941.14.17, which doesn't carry any sentence. It simply results in the forfeiture of the property, which I believe is a weapon. Now, it states on page 1 that you understand that the maximum penalty for that could be 8 years. The minimum could be 2. And that is a number that is set by the judge. And that is a mandatory term. Whatever the sentence that's selected is, it has to be served by law. Now, that is the minimum mandatory sentence. Under the law for this type of offense at this level, the Department of Corrections is authorized by law to extend that sentence, depending upon their determination of the need for that, to up to 50% of whatever the sentence imposed by the judge was. So, if the minimum sentence was imposed of 2 years, they could extend it up to 3. If the minimum sentence set by the judge was 8 years, they could extend it by up to 4 years or 12 years. So that would be the maximum possible penalty. Now, only the part that's set by the judge is mandatory. The extension is not mandatory. That'll be strictly up to the Department of Corrections. You understand that?
Yes, sir.
All right, now this offense also carries a possible fine of up to $15,000, a mandatory fine of $7,500, a license suspension of 6 months to 5 years, and again, mandatory prison term. But the license suspension is optional. You understand that?
Yes, Your Honor.
Okay. And so, just to make it clear, I think it's on page 2, there's some language in there about community control that's stricken out. Under the law, you can't get community control or probation. You can't have an early judicial release from the sentence set by the judge, because mandatory means that every day of that sentence has to be served. Now, you will get credit for any time you've awaited trial in the jail, but it is required to be served. There's no early release. You understand that?
Yes, sir.
Now, Mr. Baker, are you facing any other felony charges in any other jurisdiction at this time?
No, Your Honor.
Are you currently on community control, probation, parole, or post-release control for a felony?
Yes, Your Honor.
And what is that?
I'm on community control. I think probation too in Montgomery County.
Montgomery County?
Yes, sir.
Okay. Well, most likely, Mr. Baker, if you are convicted of this offense, that would be considered to be a violation of community control in most courts. And so if it is, and they decide to revoke your community control and sentence you to prison because of this conviction or any other violations that they allege you may have committed, then that sentence could be added to this sentence in other words, it would be ordered to be served consecutively. You understand that?
Yes, sir.
Okay. Now, under the law, once you are released from prison after serving your prison term, which again is a mandatory term set by the judge and up to additional 50% extension by the DRC, it is mandatory that you be under post-release control supervision by the Adult Parole Authority for a period of at least 18 months. That's the mandatory term, and the maximum could be 3 years, as determined by the Adult Parole Authority. And so during that period, you'll be supervised by parole officers under terms set by the APA or the Adult Parole Authority, because the judge has nothing to do with that. And if they determine that you failed to comply with the conditions of supervision, then you can be returned to prison to serve an additional period of up to 9 months for a sanction for committing any single violation, with a maximum of half of your prison term being the cap for all violations. However, if you were to commit a new felony while under post-release control supervision, then in addition, whatever sentence could be imposed by the judge in that particular case, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right, now, the charge in count 1 alleges that on or about July 28th of 2022, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in an amount equal to or exceeding 5 times bulk amount, but less than 50 times bulk amount, in violation of Section 2925.03A1 of the Revised Code of Ohio. So that's the charge of aggravated trafficking of methamphetamine, the second-degree felony with the penalties I've just described. Count 4 alleges that on or about June 13, 2023 in Highland County, Ohio, you had in your possession a Walther PPS 9mm handgun, serial number AU 5395, a magazine and 4 bullets subject to forfeiture due to its instrumentality in the commission or facilitation of the offense, as defined in Ohio Revised Code 2941.14.17. So that's the charge that would result in the loss of that weapon to the state. Now, Mr. Baker, do you understand what it is you've been accused of having done in each of those counts of the indictment, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
And have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, the third page of the plea agreement has several sentences that are underlined and printed in bold, which I will read at this time. Defendant will enter a plea of guilty to count 1 and count 4. State will dismiss remaining counts. State defense jointly recommend 3 years mandatory incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to the forfeiture outlined in count 4 of the weapon. Defendant agrees to repay by money to the task force in the amount of $375 joint and several with Corey Price. Is that your understanding of the agreement?
Yes, sir.
And has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, Mr. Baker, the matter of sentence is up to the judge, not to the parties. And so even though there's a recommendation from both parties as to what the sentence should be, which is 3 years out of the maximum of 8, the court is not bound by that agreement. And so if you plead guilty, if I decide that that's not the correct sentence under the law, I could impose a sentence of up to 8 years mandatory, in addition to a fine of $15,000, mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Now, do you hold any kind of a license or certification from any state governmental agency that governs any occupation or profession in the state?
Like a license for a vehicle or just?
No, like, say, a bus driver, barber, something like that, that's licensed by a governmental agency.
No, I do not.
Okay, thank you. Now, you have certain constitutional rights, you must understand, before I can accept a plea from you, Mr. Baker, in this matter. First of all, you do have the right to counsel, and you've employed Mr. Satina. Now, in the event that you did not have the funds to pay Mr. Satina to continue to represent you in this matter, the court would appoint an attorney for you. And so the only reason I bring that up is this. I don't want anybody pleading guilty because they don't think they're going to be able to afford to continue to pay their attorney to represent them, because if that's a problem, then the court can't appoint an attorney for them. So is that a concern of anything at all at this point in your decision to plead guilty here today?
No, sir.
All right. Now, you have a right in this matter to have a jury trial on both of these charges, Mr. Baker, which means that 12 people would be selected from a group of citizens that reside in Highland County that are called for jury duty on your trial date. After they are selected, the evidence would be presented. They'd be instructed on the law by the judge at the end of the evidence. And then that jury of 12 people would have to decide by unanimous verdict, meaning all 12 of them would have to agree, on whether the state proved your guilt on either or both counts. Now, if you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Baker, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions of those witnesses, your attorney would ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Baker, you have a right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. What that means is that if you have witnesses you're not certain can come in voluntarily at your request, the court issues a court order, which is a subpoena, and it forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If your decision is you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to talk about it except in one situation. There's a jury trial and you do not testify. The judge instructs the jury that because that is your right, they cannot consider that for any purpose. Do you understand that?
Yes, Your Honor.
Now, Mr. Baker, you are presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any defense at all in that trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt, but proof beyond a reasonable doubt on every essential element of each of the two charges, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty, Mr. Baker. Not guilty plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all of the rights I've just described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime, and that plea waives or gives up all the rights I've described for you today, except your right to have an attorney, which you always have no matter what your plea. But without exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court, which is what's likely to happen here. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Baker?
Yes, sir.
Right. Now, do you have any questions about the charge or the possible penalties in either account?
No, I do not, Your Honor.
You understand them?
Yes, sir.
Do you have any questions about the plea agreement?
No.
And again,
Yes,
you understand that whatever sentence is imposed has to be imposed. It's mandatory to serve all of it, and there can be no early release.
Yes, sir.
Okay. And again, you understand that the recommendation on the sentence is not binding on the judge.
Yes, sir.
Now, do you have any questions about the constitutional rights I've explained?
No, sir.
You understand that?
Yep.
Do you have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
Yes, sir. Well, no, sir.
You understand it?
Yeah.
All right. Is there anything you would like to speak with your attorney about before we go any further?
No, sir.
Do you have any questions about anything that I've explained to you here today?
No, sir.
Then is it your decision to withdraw your not guilty plea to counts 1 and 4 and plead guilty to those pursuant to the terms of the plea agreement?
Yes, sir.
Did you say no or yes?
Yes, sir.
Okay, thank you. Then as to count 1, which alleges that on or about July 28, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code, the charge of aggravated trafficking of methamphetamine, a second-degree felony, carrying a mandatory prison term of at least 2 years up to 8 as selected by the judge, with that being a possible maximum of half of whatever that term imposed by the judge is being added by the DRC, a fine of up to $15,000, a mandatory fine of $7,500, a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
And then as to count 4, which alleges that on or about June 13, 2023 in Highland County, Ohio, you had in your possession a Walther PPS 9mm handgun, serial number AU5395, a magazine and 4 bullets subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined in ORC Section 2941.14.17. A forfeiture of that weapon to the state. How do you plead?
Guilty.
All right. The court finds that on this day in open court, the defendant was advised of all of his constitutional rights made a knowing, intelligent, and voluntary waiver of the same pursuant to criminal 11. The plea is accepted and ordered filed. The court finds the defendant guilty of counts 1 and 4 as charged in the indictment. Counts 2 and 3 are dismissed. I do believe I forgot to ask you, are you a U.S. citizen?
Yes, sir. You asked me.
All right, thank you. All right, now, also, I noticed that the jacket in this case by the clerk says Errol T. Baker 3. The indictment says Errol Tyrone Ty Baker. Is there any objection to that?
Yes, sir. That's fine, Your Honor. I'll make sure the entry says the 3rd.
All right, thank you. All right, so I'm going to go ahead and mark, add 3rd to the face of the indictment, and then also on the heading of the indictment for the record. All right. Now, inasmuch as this is a mandatory sentence, there's no option the court has. I'm going to go ahead and proceed with sentencing forthwith. Anything from the state regarding sentencing?
Thank you, Your Honor. The state would ask that the court follow the joint recommendation. The forfeiture of the handgun in this case would be to the Greenfield Police Department, and the restitution in this case is $375 to the task force, joint and several with Corey Price. That's all, Your Honor.
All right, Mr. Satina?
Thank you, Your Honor. Mr. Baker is a young man. I believe he's 19 years of age today. He did not have the advantage of a mother and father, both of which were consumed by drugs and crime. His grandmother has stepped up to support him, and he's very lucky to have her. I would submit that he's young enough to be rehabilitated. I can tell you that he's experienced a significant turnaround while he's been in the jail over the last 60 days. He's been very remorseful. He has a mature attitude. He has a new baby girl that he's to be a father to. And he's looking forward to getting this sentence behind him and becoming a law-abiding citizen. I believe there's 60 days of jail time credit. We ask that the court follow the joint recommendation and impose a 3-year term.
All right, Mr. Baker, anything you would like to say?
No, Your Honor.
And were you arrested on the 13th or 14th of June?
The 13th.
All right, I thought that's what it was, but wasn't positive. And how old are you, Mr. Baker?
19 years old, sir.
Well, yeah, your attorney's right. You're a young man. You do have a lot of life ahead of you if you decide you want to change. And I see, you were put on. You've already were put on probation or community control in Montgomery County for this, for aggravated possession of drugs, and here you are, 19. You got a conviction for a second-degree felony, which is a mandatory prison term. So, it's a serious crime for such a young individual, but hopefully once you've completed your sentence that you'll decide that you want to deal with your issues and change your life as your attorney has indicated. So it is the judgment order of the court that you be in our hereby sentenced to the Correctional Reception Center in Orion, Ohio for a period of 3 years. That will be a mandatory sentence minimum, with the possibility under the law that could be extended by up to 50% or 1.5 additional years, for a maximum of 4.5 years, as determined by the Department of Rehabilitation Corrections. According to the calculations I have, you have 64 days of jail time credit. So that'll be the order from June 13th till today is 64 days as I calculated. Now, upon completion of that sentence, which could be extended, as I indicated, up to 4.5 years by DRC, it is mandatory that you'll be put under post-release control supervision under the term set by the Adult Parole Authority and be supervised by a parole officer for a period of at least 18 months with a maximum of 3 years. And if during that period of time you've failed to comply with any of those conditions, then you could be returned to prison to be required to serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term, or 1.5 years, for all violations. However, if you commit a new felony while under post-release control, then in addition to whatever sentence could be imposed by the judge in that new case, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater, and that would have to be served consecutively the sentence in the new case. You're also ordered to pay the court costs, which judge would grant an executioner's order. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the clerk or the court could allow you to do community service and give you credit for each hour you worked and an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. Community service would have to be done in this county after you get out of prison, not while you're in prison. It's also ordered that you pay a mandatory fine of $7,500 and that you make restitution in the amount of $375 to the Highland County Task Force, jointly and severally with your co-defendant, Corey Price, and that'll be payable through the Highland County Victim Witness Restitution Escrow account. You'll pay any service fees that are charged for that, and the weapon specified in count 4 is ordered to be forfeited to the Greenfield Police Department. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, you're remanded back to custody then, Mr. Baker, thank you.
Thank you, Your Honor.
Deputy, if you would bring in Melissa Norris next, please.
Yes, sir.
All right, are you Melissa Norris appearing there from the jail?
Yes, sir.
All right, this is case number 23 CR 137, State of Ohio versus Melissa Norris. Ms. Norris is appearing by video from the jail. Her attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. The defendant is charged in a 4-count indictment with murder, a firearm specification, felonious assault, and tampering with evidence. I believe this is the first pretrial, and the final pretrial is set for September 6th, and we have a trial date of September 25. Now, I see that looks like the state has provided discovery, and the defendant also has filed a compliance with discovery. And I see there has been a motion for a psychiatric evaluation to establish competency to stand trial. And that's filed actually with Mr. Wagner. I forgot to add, Mr. Wagner is co-counsel, I believe, with Mr. Armentrout. Is that correct?
Yes, Your Honor.
Okay, oh no, there it is. I didn't see it. I overlooked it. So you are on there. Okay, I apologize for the oversight. All right. The court then will, since that issue has been raised, the court will order a evaluation as to the next hearing said is coming up September the 6th. So that's probably not going to be doable. So finally this motion will toll the speedy trial time